A U.S. Air Force officer who publicly called for President Donald Trump's impeachment is now facing rare criminal charges under military law. Major Jason Watson has been charged after a series of public statements and actions criticizing Trump, including a protest in uniform at the U.S. Capitol. And this case could become an important test of where the U.S. military draws the line between political speech and military discipline. Here's what happened. Watson was first arrested on July 1st after appearing in uniform at the Capitol and calling for Trump's impeachment and removal from office. He was arrested again last week, shortly after criticizing Trump during a CNN interview. Now, according to a charging document shared by his attorney, Watson faces 10 charges under the Uniform Code of Military Justice. That includes 3 violations of Article 88 for allegedly making contemptuous remarks about Trump. He also faces 5 Article 92 charges for allegedly disobeying orders and 2 Article 133 charges for conduct allegedly unbecoming an officer. And there is an important distinction here. The military does have rules restricting partisan political activity by service members, particularly when they are in uniform. Military law also prohibits certain contemptuous statements against the president and other senior civilian officials. Prosecutors allege Watson violated those rules in several ways. They say he participated in a partisan protest while wearing his uniform, violated regulations governing political activity, improperly traveled to Washington while on leave, and refused to wear his uniform to work after his CNN interview. Watson's attorney says his client stands by what he did. In his CNN interview, Watson accused Trump of violating the Constitution, breaking the law, and engaging in corruption. His attorney says Watson believes he acted because of his constitutional oath and wanted to speak out on behalf of others who may be afraid to do so. But the legal stakes are significant. Charges under Article 88 are rare. A review cited in the report identified only 2 convictions for contempt of officials since the modern Uniform Code of Military Justice was enacted in 1951. One came in 1965, involving an Army lieutenant who protested against the Vietnam War. The other came in 2021, when Marine Lieutenant Colonel Stuart Scheller pleaded guilty after publicly criticizing the Biden administration's handling of the Afghanistan withdrawal. Military law experts also point out that the definition of contemptuous speech is not always precise. One retired Army judge advocate said the remarks generally have to be insulting, rude, or disdainful. That could become a key issue in Watson's case. The question now is whether his statements were unlawful contemptuous remarks or constitutionally protected criticism. Watson remains presumed innocent. It is also not yet clear whether his case will proceed to trial or whether it would be handled by a special or general court-martial. For now, this unusual case is putting a spotlight on a difficult question. How far can a military officer go in publicly criticizing the president before political expression becomes a military offense?
Subscribe to One India and never miss an update. Download the One India app now.